Of year on Christmas Eve, Judge Hans-Joachim Fabricius from the Northern Gauteng High Court, he dismissed with costs an urgent application by Lion of Africa Assurance Company. The case was to compel SASSA to implement the lifting of its moratorium on child grant deductions. Now, this follows an interdict by Justice Fourie to stop SASSA from implementing a moratorium to exempt child grants from the Social Assistance Act. Kgomoco Diseko, acting Head of Communications at SASSA, joins us now to discuss this issue further. A very good morning to you. Thank you so much for joining us.
Good morning, Ayanda, and thank you for the opportunity.
That intro is full of legalities, and this one judge said that, and the other judge said that. It can get all too confusing.
Indeed.
Simplify it for us and tell us what we're dealing with here. What has just happened?
Indeed. For the benefit of the viewers at home and everybody else who's watching the program, I'll give a brief background. What happened is that on the 4th of December this year, SASSA issued a moratorium on deductions on child grants. By the way, we have three types of child grants. The normal one, the common one, which is the child support grant, the FCG, which we call foster child grant, and then the care dependency grant. The moratorium was to give effect to a situation where service providers for funeral policies would not be allowed to can deduct money for that purpose. We felt that it is very unfair because, you know, the life expectancy in South Africa is over 59 at the moment. And child grants mostly are available to children and beneficiaries up to the age of 18. Now, if from the age of 1 up to the age of 18, I'm just making an example, you deduct child grants from the mega amount of money that the children are receiving every month. At 18 years, usually, normally you'd expect that that grant, the policy will lapse because of affordability issues. Now, what happens to all the premiums that have been collected throughout the 18 years? We felt it's very unfair, and as a result of that, we then issued that moratorium. Subsequent to that, the company, as you mentioned, Lion of Africa, took us to court. We went to the Northern Gauteng High Court in Pretoria to defend this case, and you know, unfortunately for us, they won the case. And then subsequent to that, they were so enthusiastic about, you know, effecting the court decision to the extent that they went to court again to force us to implement the ruling of the 17th of December. Now, on Christmas Eve, we went to court again and we won. The application was dismissed with costs. In other words, we are not at the moment compelled to can effect what they are requesting, which is the deduction of funeral policy premiums from child grants. As a result of that, and the learned judge, Judge Fabricius, based this on the fact that the issue is a subject of a matter that is going to the Constitutional Court. So pending our appeal, it was not wise for the court to can allow that, you know, we start to implement. We can begin to implement, yes.
So I was actually just about to ask you, before you mentioned ConCourt, I was going to ask you whether or not this is the end of the matter or if you will be proceeding with more legal action. And it seems like you've already answered that this matter is still pending.
The matter is indeed pending, and you know, civil society through their organizations have shown a lot of interest in the matter. We might see some of them coming up to become amicus curiae or friends of the court in the Constitutional Court. In short, we're still going to the Constitutional Court early next year to can defend this case, and for us, we think it's a winnable case. And in the interest of justice, we've got to ensure that we respect the Constitution and we respect the rights of children that are enshrined in the Constitution.
Have you done any sort of studies or any sort of consultative process with the South Africans who are beneficiaries of social grants, obviously those who are of a consenting age, to find out what it is that they would like to do in this situation? What is it that they want? Perhaps parents or caregivers of these children whose grants are up for discussion. What do they want?
Look, the majority of caregivers are not in favor of this situation. You will remember that before 2012, funeral policies where people who were taking out funeral policies are people who benefited from the old age grant. Now, it's a new thing completely. for people to start saying that they would want to deduct funeral policy grants, funeral policy premiums from child grants. It is a totally new thing. And we are of the view that the majority of our beneficiaries are behind us on this one.
There is a lot that is at stake when it comes to these grants. They're a blessing and sometimes otherwise in some situations where you find, for example, that the money is not being used where it needs to go to, or unscrupulous and dubious people are waiting to squander that money in one way or another. How have we taken another look at the system to make sure that it does what it was set out and intended to do?
Indeed, you've got a point. It is true that many people are taking advantage of our people, based on the fact that some of them are ignorant, some of them are semi-literate, and so on. But as SASSA, we have taken serious steps to ensure that we protect these people. For instance, almost on a monthly basis, our collaboration with the security forces bears fruit, in the sense that a lot of loan sharks are actually arrested and prosecuted for these matters. And people who steal money from us in the system are also taken to court and they're given harsh sentences. So as SASSA, from our side, we've done a lot. And
when speaking to those officials, have you tried to speak and perhaps engage insurance companies, assurance companies, those with policy offerings and products, to say to them that these are the limitations? Have you perhaps have a stakeholder engagement with them to say this is how far we can go to tolerate this kind of behavior and no more?
You're quite correct. We have engaged them on a continuous basis. But also, they are aware of the law. Section 26A of the regulations of the Social Assistance Act does allow for deductions against funeral policies, but under certain specific conditions. And we feel that in this case...
what would those conditions be if a child is terminally ill, or what would those conditions be?
Look, generally, the Section 26A of the regulation provides for those deductions to be made through the social grants. And the condition is that the beneficiary must give consent, or the caregiver, plus SASSA must give consent to that. So in some cases you find that, a service provider just takes the shortcut and they sign up a beneficiary without informing SASSA. So that's one of the issues that we're contending with.
So when does the matter go to court once again?
Because of the recess, we've not been made aware of a date, but we will communicate it as soon as we have it.
Thank you so very much, and I trust that you will avail yourself for a follow-up interview here on Morning Live as well. It is a very, very important matter that we should discuss, I think, going into 2016. So I have your word.
Yes,
on
yes,
live
indeed.
television,
I can confirm.
whether it goes in your favor or otherwise.
It does not matter.
Thank you so very much.
Thank you very much, Ayanda, for the opportunity again.
Appreciate it. Thank you so much. From SASSA, Mr. Kgomoco Diseko, the acting head of communications there. Let's leave it there, at least.